counsel. Mr. Austin has Bates. Correct. Okay. On the record in the matter of the people of the state of Michigan versus Shannon Bates, 24-01935, Councilor Pierce.
Good morning, Your Honor. Casey Markarian, appearing on behalf of the people, first making a motion to practice under Michigan Court Rule number 8.120.
Motion granted.
And thank you, Your Honor. Good morning, Jared Austin, appearing on behalf of Mr. Bates. He appears with us remotely from Hingham County Jail.
Okay, Mr. Bates, you can hear us, correct?
Yes, Your Honor.
Okay, very good. Today was the date, the time that was scheduled for sentencing. I do have a pre-sentence report. It was prepared on September 17th. Did you get a copy of that, counsel?
I did, Your Honor, and I shared that and reviewed that with Mr. Bates.
Needs to make corrections, updates, or deletion.
Just a couple minor ones, Your Honor. I think they have the credit miscalculated by a day. I had 92 days when I computed that. And it mentions the pending circuit court matter that he had that was still pending, that he was awaiting sentence on, which was true at the time that the report was generated. As an update, I would tell the court that the circuit court has sentenced Mr. Bates on that matter. He was sentenced to time served with no probation.
Time served, no probation. Okay, I have that noted in mine as well. That he had a pending matter before Judge Aquilina.
That is correct. Possession of a controlled substance.
Okay, any other updates you made at this time?
None to the body of the report or the content of anything.
Make allocation.
Thank you, Your Honor. The recommendation is the probation department feels that Mr. Bates is not a good candidate for probation. And I certainly understand why they reached that conclusion. I'm not necessarily disagreeing with that. I would ask the court to consider far less time than what is being recommended. I would first ask the court to consider sentence Mr. Bates to the time he has served. He has served more than 3 months on this matter, but alternatively, I would ask the court to consider sentencing Mr. Bates to far less than what is being recommended, which is the maximum amount. I believe all of Mr. Bates' prior criminal history consists of nonviolent drug, property, or traffic-related matters until he had the most recent matter that he was sentenced on in the circuit court. In this matter, I believe it had been several years. He had gone several years without having any involvement in the criminal justice system. He has very little money and income, so he does have stability issues that I think would present a challenge for him to complete probation. So I would ask the court to consider sentencing him to time served. And I also think, positively speaking, for Mr. Bates, is he is outlined that he has plans to help himself once he is released to get into an inpatient treatment program, because he does have that realization that he does have struggles with drugs that he needs to address, and hopefully he can do that and get his life back on a stable path. Thank you.
Did your client want to make a statement at all?
I believe he indicated to me yesterday he did wish to make a statement to the court. Is that correct, Mr. Bates?
Yes, yes, sir. Yes, Your Honor. I'd like to make a statement.
You can do so at this time, sir.
Well, like I said, I know I made some things during my pre-sentence. I found out that sister of mine is watching my sick uncle, and now let's took some bond money from me that my brother split up for me. But nevertheless, I felt like nobody was listening to me until I got into AA/NA and Bible study. That's why I felt like when I was listening, I was taking it seriously. And I said, I'm getting trespass to people with it, and I want to apologize to the court. And for me and Miss Stampier's aunties, we've been on and off again for 16 years. And I'd like to also ask for forgiveness for saying, Mary women married women, women's lib. So I felt like nobody was listening to them. I said, but at the time, I am taking this seriously. And I had my attorney call, set up my appointment for MMRS, was what started it. This whole issue was me telling her, I seen a couple of friends of ours for 30 years that are clean. And they looked good. I was proud of them. And I wanted that. You know what I'm saying? And it stems from all these years, I was her connection. And for me to tell her no, because you know what I'm saying? Lots of people see burn bridges, you know what I'm saying? But for me to tell her no, I don't want to do this no more. I don't really careful, but I still apologize, you know, for and I just anything I've said, my attitude in the past, you know what I'm saying? But that was before I went to AA, so that's NA, and took it seriously. Had him call me and Rich Recovery Service, and as soon as I get out, they're waiting for me because I have to do this. Because I said I don't want my kids following in my footsteps. Because I got my second oldest is already in prison in Louisiana. I'm already a 2-time loser, and I have a couple 17-year-old boys and a 3-year-old. Well, the 3-year-old one's in the system with those who's grandma, but she's 70-something years old. And without me going to rehab, they're not going to give me my paternity rights back. I have no choice. So I asked the court, begged the court to let me go ahead and get out of here so I can continue on my path. And my path is to go to first to go to rehab, then go to sober living. You know what I'm saying? I'm just sick and tired. Like Judge Aquilina said, I'm at the tunnel. I said this, I'm 53. One of my favorite people in this world, what used to be one of my favorite people in this world, was Bernard McCullough, aka everybody else knows him as Bernie Mac. He passed away at 54. I'm 53, so it tells me I'm not promised. But I want to at least die knowing that I tried to do what I needed to do, getting my kids out of the system. I'm the only one that's hold up is me. And I just said, let's apologize to everybody if I offended anybody, which I know my interested. But I just want to get this over with so I can go ahead and go to Richmond so I can get set up for rehab. I don't want my lawyer wasting his time making this call and appointment for me for nothing. So with that, I appreciate the court giving me a chance to apologize to the court. Thank you very much.
Thank you. And thank you for addressing the court and being candid about your situation. And I hope that this is a juncture in your life where you recognize you need to make some change. I reviewed your prior criminal history. I reviewed the pre-sentence report. You have a long-standing history involving substance abuse, which is at the very core of your criminal history. This is why you are behind bars as we speak. The only person who's going to address this and make the change that stops the cycle is you. Mr. Austin can't do it, although he can support and try to align you with support. Judge Aquilina can't do it, although she could have ordered you to do something. I can't do it, although I could have ordered you to do something. You got to decide that you're going to do it. We order people to do treatment all the time. Sometimes it works, sometimes it doesn't. And the difference is your mindset. The person's mindset when they decide, I don't want to do this anymore. I want to make a change. I want to be healthy. I don't want to have a poisonous substance control my life. So that's up to you. And you've indicated to the court you got family and friends that are relying on you. You got to first be able to rely on yourself. And you're not able to right now. You need to take care of Mr. Bates, get Mr. Bates healthy. And I'm sure your family would love to see that. They want to see you healthy. They want to be able to enjoy you. They can't enjoy you behind bars and they can't enjoy you in a grave.
No.
And those are your two options if you don't stop doing what you're doing. You understand that?
That's
I'm again happy to hear that you have decided that you're going to do some treatment. You're not in this court today based on any drug related charges. The one that you had pending before Judge Aquilina that you got credit time served was one relative to a possession of a narcotic. This one was police officer assault and you pled guilty, I'm sorry, attempted police officer assault and you pled guilty to misdemeanor reckless driving. I'm not going to sentence you to 365 days for that because I think you do need to do treatment. And I'm not going to supervise it. I don't believe you're a good candidate or you've not been a good candidate for probation. I think you need to take corrective action. If you don't, I can assure you, you'll be back here if you are still living, if you don't take corrective action immediately. And that's not what we want for you, sir. I can promise you that. You understand?
Yes, I do, Your Honor.
Okay, as to the count of, well, I think it was amended count 2 of attempted police officer assault, the sentence is 92 days, Ingham County Jail with credit for time served. As to count 3, which is reckless driving, the fine is $250. A report back to the court once you're released and provide me evidence or information as to when you're going to make payments on that, sir.
Yeah,
Okay. Do you have any questions at this time?
no, Your Honor. But thank you. I know it's on me. I can't, started over, say my friends, they look great. You seen what I saw, you wouldn't believe it.
Well, I do wish you the best and hopefully I won't have to see you in this capacity anymore. And the next report I'll get will be a positive one. Okay, sir?
Yes, sir. Thank you.
You're welcome. Any additional matters for the record, counsel?
I have nothing additional, Your Honor. Thank you.
Nothing from the people.
You're all set, Mr. Bates.
Thank you.
You're welcome. You can let the deputy know that you're all set.
Okay, thank you.
That's the wrong one. Oh, okay, Ms. Robinson has Mr. Dunneback.
Yes, Your Honor.
We bringing him up or are we waiving his appearance?
You can waive his appearance.
On the record in the matter of the people of the state of Michigan versus Dennis Dunneback, 24-02690, counsel appearance.
Good morning, Your Honor. Case Markarian appearing on behalf of the people.
Karen Robinson, Assistant Public Defender for Mr. Dunneback.
Okay, today was the date that was scheduled for a preliminary examination. I have, I think, a CATS update here indicating that Mr. Dunneback presented with significant mental health symptoms, and due to that, CATS believes he would benefit from ongoing mental health treatment and medication and compliance. I also saw Mr. Dunneback, or attempted to this week, and that didn't go so well. How are we proceeding today?
Your Honor, I'm in the process of filing a competency petition for him.
Okay, I'll note that in the file that we're going to proceed with the competency and the court will find a good cause, obviously, to go beyond the timeline. We'll set this for a review. Any additional matters for today's record?
From the people.
No, Your Honor, thank you.
Thank you. You're all set. Mr. Sparks.
Morning, Your Honor.
Have Mr. Brookwire,
Yes, he's in custody. He's downstairs. He is brought
Okay,
over.
we'll have him
Cook County
brought-
this morning.
we'll have him brought up.
Thank you.
Mr. Austin is covering Ken Pittman.
That is correct, Your Honor. Mr. Pittman is here. For
Okay, on the record in the matter of the people of the state of Michigan versus Kim Antonio Pittman. That's 24-02049. Counsel appearance.
Good morning, Your Honor. Casey Markarian appearing on behalf of the people.
And thank you, Your Honor. Good morning. Jared Austin appearing on behalf of Mr. Pittman, filling in for counsel of record, Mr. Goodrich. Mr. Pittman stands present to my right.
Okay, Mr. Pittman. We have a pre-sentence report that was prepared back on September 13th. Counsel, did you get a copy?
Yes, Your Honor, and we've had an opportunity to review that with Mr. Pittman. Doesn't appear that we have any corrections or updates to that report, Your Honor.
You can make allocution.
Yes, Your Honor, thank you. I think there's a lot of positive things mentioned for Mr. Pittman, as the report indicates. The probation department even explicitly stated that he's made a lot of changes to, turn his life around, despite his criminal history. Then I think a few years since his last conviction, that was a misdemeanor drunk driving offense, I believe. I think it's been over 15 years since he's been convicted of a felony. And as the report indicated, Your Honor, is that Mr. Pittman has been consistent in his interview with the probation department, consistent in that interview with what he told the police. I think he's demonstrated genuine contrition and remorse for his actions, takes accountability for his actions. He's working full time. He's working towards getting a nonprofit started for an issue that's very near and dear to him. So I think there's a lot of positive things to say for Mr. Pittman, Your Honor. I would ask the court to consider a sentence of fines and costs given that. But any alternative, if the court believes that some term of supervision is needed, then I would ask the court to adopt and not exceed the short-term of probation that is being recommended. Thank you.
Did your client want to make a statement?
Yes, Your Honor, this has a, for the PSI investigator. This is a situation that I think was what happened. Should have just, I'm a felon, I had ammunition. I was in the process of getting rid of it. Should have got rid of it. I was just moving with my cousin, stuff in his apartment permit, which was his.
You say something about your cousin, you said?
Yes, he passed away Memorial Day. His name is Damien Pittman. So I was moving a lot of stuff from his place to get the pressure off of my mother and my aunt, because I say his sister. So a lot of his stuff was there. That morning, when I realized the clip was there, that's when I said I cleaned up the car. And that's when the situation happened, as what happened, why I had the clip on. And the clips came from his house. I told the PSI investigator, you can ask the, I'm not gonna come here and lie to you. You can ask the Ingham County Sheriffs, they got there. They took the guns out of here, stuff like that. When I had that whole man apartment in my house, there was clips there, gas slugs, whatever. I was constantly unpacking the stuff. I gave his friends hats, memorial. I got the video that I cleaned the house out right here on my phone.
I'm not disputing that you cleaned out your cousin's house.
Simply, if I would have got rid of it, I got rid of a few of them. If I would have got rid of that, the rest of them that was in the house, I wouldn't. So.
But you knew you weren't supposed to have it.
Yes, I did.
No.
Get rid of it.
No. And so you understand the behavior was wrong. You're gonna take corrective action. You've taken responsibility for it. Okay. I've reviewed your pre-sentence report. I've reviewed your criminal history, which is kind of lengthy. However, as indicated by your attorney, the last conviction was that of a impaired in 2020. You gotta make some better decisions, sir. Your criminal history shouldn't be this long. You are before the court with information that you seek to start a nonprofit and engage in some activity that I would hope is meaningful to the community. But you're not making good decisions while you're doing that. You gotta start with yourself. Even though you were doing something positive for your family at the time of this incident, you didn't do enough to protect yourself and to make sure that the actions you took were in proportion with the law based on your status. And you gotta do that. You gotta do better about that. Responsibility. Be responsible, sir. The report indicates that you would be a good candidate for a term of probation. I'll adopt the report. You'll be sentenced to 6 months reporting probation. While on probation, you have the following conditions. You're not to engage in any assaultive or threatening behavior. You're not to possess a firearm, ammunition, or weapon of any kind. And you're not to use or possess alcohol or marijuana or other controlled substance unless you have valid prescriptions. You need to provide proof of those prescriptions to probation, okay? While on probation, you will be required to submit to random preliminary breath testing and urinalysis testing. You're responsible for the cost of that, okay? You're still currently employed. You'll maintain your employment and provide evidence of that to probation. Do you have any questions so far? Okay. It's a $30 per month oversight fee that you would be responsible for while on probation. So it's $180 in oversight fees. There's a $75 crime victim rights fee that must be assessed with a $50 state minimum cost that must be assessed. I'll waive discretionary fines and costs. You'll make monthly payments, okay?
Yes,
Lastly, there's an advice of rights as to probation. It states here that you have the right to request early discharge from probation once you complete half the original term ordered by the court. You can make a request on your own, or your probation officer can make the request. In order for you to make the request, you must not have violated your probation within the 90 days preceding the request. So you're only on probation for 6 months. So 90 days in, you can make a request to have me discharge you successfully, as long as you don't violate, because I'm not ordering any additional requirements other than you make your fines and cost payments and you maintain employment. And so you would use the court's M512 form, which is listed on there, that's on the court website, or you can get it from your probation officer. You would file a copy of the request for early discharge with the probation department, and you must serve a copy of it on the prosecution's office. The prosecutor has 14 days to respond in writing to your request with any written objections. You understand so far?
yes,
If it's set for a hearing to address your request for whatever reason, you would have the right to be represented by counsel, but you'd have to hire the attorney. You do not have the right to court-appointed counsel for any request for early discharge from probation. Do you have any questions about that, sir? Okay, I need you to sign at the bottom so I know that you reviewed or that you were advised of these rights. When you leave here today, I want you to go down, check in with probation to make sure they have accurate contact information for you, and then you'll be all set today, okay?
yes,
Any additional matters for the record?
Nothing from the people.
I have nothing additional on behalf of Mr. Pittman, Your Honor. Thank you.
Thank you. Good luck to you, sir. This is that file. Okay, on the record, in the matter of the people of the state of Michigan versus Randy Lee Wickwire, 23-00706, council appearance.
Good morning, Your Honor. Assistant Prosecuting Attorney Melanie Smith on behalf of the people.
Good morning, Your Honor. Jacob Sarris, the fourth Assistant Public Defender here on behalf of Mr. Wickwire, who's present at council table. He stays to my right.
Okay, today is the date that's scheduled for preliminary examination. And my understanding is that there's going to be a waiver to circuit court.
Correct, Your Honor. The people will unconditionally waive their right to a preliminary examination here in the district court. I believe the defendant is prepared to do the same. There's no offer to place on the record at this time. Mr. Wickwire does have another pending file in circuit court. The goal will be for further negotiations to continue towards a global resolution.
That's correct, Your Honor. Thank you.
Okay, Mr. Wickwire, you want to waive your exam?
Yes, ma'am.
You understand that you have the right to have the preliminary examination here in the district court. You have the right to require that the prosecution put forth evidence that would establish sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime before the matter can be bound over to the circuit court?
Yes, ma'am.
Anybody threatening you to get you
No, ma'am.
to waive your exam?
No, ma'am.
You said no before I even told you or asked you what they were threatening you about. So that there's no threats at all right now,
No, ma'am.
correct? Okay. Anybody promising you anything to
No,
get you to waive your exam? Okay. It's like September, it's almost gone. Who's that? Let's see. The bind over dates October 9th. That's the date that the circuit court's going to get the file from the district court, okay? You do not need to appear in circuit court on that date, okay? Your next court date will be a pretrial. Your attorney will be made aware of that. You're not being held on this at all because you got a PR bond, so you're not doing time.
Correct, Your Honor. He's serving sentence up to Clinton County at a probation file.
Okay, sounds good. Any additional matters for the record? Bond will continue.
No, Your Honor, thank you so much.
No, Your Honor. Thank you.
You're all set.
Thank you.
Now let's see, who do we need to bring up?
I will go find you a prosecutor, Your Honor.
Yeah, because I think mostly everybody else is in. Ms. Donnelly has
Yes,
someone. Underwood, maybe?
Underwood, the prosecutors are amending the RNO to an attempt, so he can be, and I talked to him, so he can be brought.
Okay, we can bring up Underwood.
Okay.
Ready for Prisinga, Your Honor.
I'm sorry, I didn't hear you.
We're ready on Prisinga, Your Honor. I apologize, I was talking to the victim on Terrell Williams. She's right out.
On the record in the matter of the people of the state of Michigan versus Kevin Huizinga, 24-02739. Council appearance.
Good morning, Your Honor. Case Markarian appearing on behalf of the people.
Good morning, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Mr. Prisinga, who's standing to my right.
Okay, Mr. Huizinga, today was the date set for an exam, but we said we would treat it as another probable cause conference. Said that you were in the process of obtaining a new attorney.
That's accurate, Your Honor. He's in the process of obtaining Mike Nichols of the Nichols Law Firm. And I know he's been in constant contact with Mr. Nichols. We are requesting that he be allowed to waive his 21 days and set this matter out so that Mr. Nichols can get retained officially, file an appearance and obtain discovery. We, as we talked about, or as the court referenced, witnesses were called off today, so that didn't happen.
Okay, and so, Mr. Huizinga, you understand that you have the right to have a preliminary examination within 21 days of the date that you were arraigned?
Yes, sir.
And due to the fact that you are trying to retain Mr. Nichol, are you willing to waive the timeline so we can reset this?
Yes, sir.
Okay, I'll get you a next court date, and then obviously I don't know Mr. Nichols' schedule. We can set this for another PCC so that Mr. Nichols can make sure, we can make sure he's retained and that he gets discovery, and if he needs to provide us his schedule for exam, we can do so. We can do probable PCC on October 17th at 8:30. October 17th at 8:30 will be your next probable cause conference, okay? And November 8th at 9:30. We'll set the exam for November 8th at 9:30 for now, okay? Have any questions?
No, Your Honor.
Any additional matters for the record, counsel?
Nothing from the defense, Judge. Thank you.
We'll get you a notice to appear for those things, okay, sir? Thank you.
The, I think we're waiting on Mr. Freeman for a couple. Mario Scott should be up to your honor.
And I need a Donnelly for a few.
Yeah. I think we just lost her, but Freeman and Donnelly both have some. I don't know if after we just posted that, we might be able to do her. You know, she needs to be brought up. You're gonna need us to go on the record about Maddie Horton, Your Honor. That's the one that Kareem Johnson dropped off the stip in order to adjourn yesterday.
Sarah's on the record last.
Why do you go on record for Horton?
Maddie Horton. That's the one.
No,
that
he's
was-
not here.
Okay. That's the stip to adjourn.
Yeah, I saw it.
Should- should- I was doing too much, yeah. But you're looking outside.
No.
you can be seated.
John Underwood.
On the record in the matter of the people of the state of Michigan versus John Underwood, 22-00786. Council appearance.
Good morning, Your Honor. Case Markarian appearing on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant, John Underwood, who is present and sitting to my right. Mr. Underwood is in a wheelchair, Your Honor, so we would just be asking that he remain seated.
Today was the date and the time that was scheduled for a preliminary examination. Oh, we proceeded on this.
Your Honor, the people will be moving to amend this complaint to keep it as a misdemeanor and keep it on your misdemeanor docket. Specifically, we'll be amending count 1 to attempt resisting and obstructing, keeping count 2 of assault battery. It's the same.
October 15th at 2. October 15th at 2. Yeah, October 15th at 2 p.m. Have any questions today, Mr. Underwood, for the court? So matters for the record.
Nothing from the people.
Yes, Your Honor, I do want to briefly address bond. Thank you. Mr. Underwood has 2 cases with this court. One of them is a misdemeanor. Both of them are significantly old. Mr. Underwood has absconded from this court for, I think my case was from 2022. So he has significant health issues. I don't believe that one of those cases he thought was dismissed. So my understanding is that he has $500 cash surety on the misdemeanor case. He needs $300. I think it's a $3,000 cash, 10% on this case. He has a hold in Eaton, and right now the misdemeanor case is set for next Tuesday. So what I was going to hope for is he's to have a lower bond or PR in this case. He will remain in custody until he sees you on Tuesday on the misdemeanor, at which time I believe I'll ask Mr. Lee to make also the similar request and see if he can be released to Eaton County. So
Yes. This the case before me?
yes, 2 cases.
No, it's
that
not Mr. Lee. Mr. Lee's with Judge.
I'm sorry. Yeah, it needs to be reassigned. No, it was reassigned to Jacob Raleigh. Apologize.
Okay.
Yeah, Raleigh will be here on Tuesday for that one. So we just want to, yes, he's been in custody since he was arrested on the 11th.
Yeah, I'm gonna go ahead and set this one for the same date then.
For the October 1st.
I'm not amending this bond. I'm not going to go looking for him or readying him. We can address it after next week.
Okay, so you want this case to also be set for October 1st at 8:30 a.m.?
Yes.
Okay, I will.
So they can, the attorney can make a motion on bond at that time.
Thank you, Your Honor.
Any additional matters for the record today?
Nothing from the people.
Nothing for defense.
You're all set. Let's see. We have some people in custody. We have O'Neill. Are we running an exam?
I believe that one's going to be a mental health board referral, Your Honor.
Okay, we can bring, do you want O'Neill brought up or do you want to waive his appearance?
No, we intend to waive the timeline, and then I was going to consider a bond motion, but it is a minimal.
I mean, okay, we'll have him brought up.
Okay, we're ready on OPAN, Your Honor, and Mario Scott is just going to be an adjournment request for a plea date.
On the record in the matter of the people of the state of Michigan versus Mario Tremaine Scott 24-02634. Council appearance.
Good morning, Your Honor. Case Markarian appearing on behalf of the people.
Your Honor, Stephen A. Freeman, Assistant Public Defender on behalf of Mr. Scott, in place instead of Attorney Aaron Schroeder.
Okay, today was the date scheduled for a preliminary examination. How are we proceeding?
Yes, Your Honor, we have a plea sheet filled out. It's my understanding Mr. Scott would just like his attorney of record, Aaron Schroeder, to be here when that happens. So we'd be requesting an adjournment. I can approach with that plea sheet if you'd like.
Okay, the offers from the plead guilty to amended count one, weapons, firearms, improper possession of firearm and or upon a motor vehicle and forfeit the weapon. It's accurate.
Yes, Your Honor, we're hoping the court would accept a plea to the 5-year felony and accept that for the lesser included misdemeanor.
Okay, so you want the separate plea date?
Yes, Your Honor.
But again, the gentleman would feel more comfortable, and if Ms. Schroeder was here, if that's acceptable to the court.
October 3rd at 9. October 3rd at 9.
Sorry.
October 3rd at 9.
Thank you.
No problem. Have any questions today, sir? Any additional matters for the record?
Nothing from the people.
No, Your Honor, thank you.
We'll get you a notice to appear, sir.
Thank you.
Okay, let's see. You said already on Pocan,
Yes, Your Honor. I think it's just a waiver. Ms. Lawton's here on that.
on the record of the matter of the people of the state of Michigan versus Pocan 01521, council appearance.
Good morning, Your Honor. Jennifer Lawton on behalf of the people. And Assistant Public Defender Sarah Dolly on behalf of Defendant Rico Can, who is to my right.
Okay, Ms. Pocan is scheduled for an exam today, and there's gonna be a waiver.
That's correct, Your Honor. Defendant will be unconditionally waiving her right to preliminary examination. People also unconditionally waive their right to exam. Negotiations will continue on circuit court.
Council. Okay, ma'am, you understand that you have the right to have a preliminary examination in this matter in the district court? Yes, sir. You understand you have the right to require the prosecution put forth sufficient evidence to establish that they have probable cause that the crime was committed and probable cause to charge you with the crime? Yes, sir. You want to give your exam up? Anybody threatening you to do that? Thank you. Combined over dates October 9th, but the date circuit court gets the file from the district court. You do not have to appear in court on that date, okay? Okay? Yes. Your next court date will be a pretrial. Your attorney will be made aware of that. Your address has not changed since you were arraigned. Okay, and your phone number hasn't changed either? No, Your Honor. Okay, bond was set at 2,000 personal recognizance. That will continue. Any additional matters for the record?
Nothing from the people. Thank you.
Nothing for defense. Thank you. Thank you, Your Honor.
You're all set.
Thank you, Sidwood.
this court date. Are we running Williams?
My understanding, we are, yes, Your Honor.
for the record in the matter of the people of the state of Michigan versus Erica O'Neill, 24-02381. Appearance for the record.
Good morning, Your Honor. Casey Markarian appearing on behalf of the people.
Good morning, Your Honor. Attorney Derek Desmond, also the public defender on behalf of Miss O'Neill. Miss O'Neill is in the courtroom, seated in the wheelchair to my right. I'd ask the court to allow her to remain seated as she is in the wheelchair. Thank you.
Okay, I don't know why we're asking, I don't think they're asking to allow someone in a wheelchair. This is the second time someone asked me today. I've never made anyone in a wheelchair stand up.
That's good.
Okay, nonetheless, today's the date and the time that's scheduled for a preliminary examination. How are we proceeding?
Your Honor, this time we're asking the court to accept a waiver of the preliminary examination timeline. Mrs. O'Neill has an extensive mental health history. We're in the process of trying to collect those records. We're also intent to refer to specialty court mental health court for a assessment. At one point, she did go into bench warrant status for missing a court date. So by fact, though, I guess the timeline had been waived.
It's already been waived. Failed to appear. Failed to appear for PCC, and then the date of her exam, she must not have appeared, but it looks like she did see the magistrate the next day, after she was supposed to be here for exam.
Yes, Your Honor. It's my understanding, and she's provided me this information for the court, that she was actually in a rehab center at Meridian and started having some type of chest pains or medical issues and was sent to a hospital. I think it was Genesis Hospital in or around the Plant area. And then after getting out of the hospital, she turned herself in on the warrant.
Yeah, that's the information that I think was provided to the magistrate at the time of her arraignment on the warrant. We don't need to address the timeline. We just need to or set this out so that she can undergo assessment or referral. We need 30 days for that.
Yes, Your Honor. Thank you.
It'll be November 7th at 9:30.
November 7th at 9:30. Any additional matters for the record?
Will that be a forensic review on that date and time, Your Honor? No witnesses are required.
I thought you were requesting mental health court.
We are going to make that referral, Your Honor. For the upcoming court date, is that going to be a PCC or PE?
That's going to be for another PCC.
Okay.
Thank you, Your Honor. And I would like to address one if the court would allow it.
Yes, you can do so this time.
Thank you, Your Honor. Your Honor, we're asking the court to consider reinstating Mrs. O'Neill's PR bond. She's advised me, and she did advise the magistrate in court the day the court through me, that she was did not intentionally miss the last court date. She was, according to her, in a hospital at that time, having a medical issue. She advised me that upon release, she turned herself in on the bench warrant. She advised me if she is released, she would be staying with her father at the Flushing address that I think the court already has. If not, I can give the court that address and a phone number. She does have some medical issues. I think she was recently diagnosed by a neurologist with epilepsy. It's my understanding she may need to do some follow-up with that doctor. That was a recent diagnosis. She's obviously in a wheelchair and has some severe mental health issues. I would ask the court, if the court is to grant her a bond, to include a bond condition that she continue with community mental health or other mental health providers with any treatment and medications as prescribed by those individuals. Thank you, Your Honor.
The bond will be reinstated, but it was 1,000 personal recognizance. And her future court date, she'll have no problem appearing.
Do not think so, Your Honor. You have rights, correct? Advising she does not have any transportation issues, Your Honor.
Okay, all other bond conditions, including a no contact order with the electric and no continue. Any additional matters for the record?
Nothing from the people.
Just so tell Ms. O'Neill, if and when you're released, please contact pretrial services within 48 hours, okay? Nothing further from the defense, Your Honor.
You're all set.
Thank you, Your Honor.
And then we can bring Williams up.
That would be the information from pretrial services.
On the record in the matter of the people of the state of Michigan versus Terrell Williams, 24-022226.
Morning, Your Honor. Case Markarian appearing on behalf of the people.
Morning, Your Honor. Stephen A. Freeman, Assistant Public Defender, appearing on behalf of defendant Mr. Williams, who is standing to my right.
Okay. Today's the date that we're to proceed on a preliminary examination. There's also simple court here. 853 bond violation.
Please forgive me for interrupting, Your Honor, but if the court could keep its voice up just a little bit.
Oh, I apologize.
I'm terribly sorry.
Yeah, there is a PA 53 bond violation. I think there's at least two that also need to be addressed. Are we ready to proceed?
Yes, Your Honor, I have the necessary witnesses here for the sake of judicial economy. If we could take testimony for the bond hearing and the preliminary exam all at the same time, I would prefer that. I also have some stipulated exhibits here that I'll present to the court when necessary. It's stipulated people's exhibits number 1 through 11. If I could please approach with stipulated exhibit number 1, it's a certified copy of the PBO.
You can approach. Any other preliminary matters?
No, Your Honor, people are ready to proceed.
Nothing from the defense, Your Honor. Thank you.
You can call your first witness.
People call Sierra Johnson.
Can I have you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
You can have a seat. Okay, there is a microphone that is in front of you. The purpose of that microphone is so that the system can record and pick up all of your responses. It does not, however, amplify your voice. And so we have to speak loud because one of the attorneys needs us to speak loud so they can hear. Do you understand that? Okay, all of your responses must be loud and clear. We can turn that off. They must be loud and clear, must be verbal. You can't do head nods or head shakes because the system can't pick those up, and and ahs. It's hard for us to differentiate that in the system. So you need to do yes or no. If you forget, we'll remind you, okay?
Okay.
If there's an objection from either attorney, you'll stop speaking so that I can address the objection, and then I'll advise you and tell you whether or not you can give us that response or not. First, state your first and last name and spell both.
Sierra Johnson, SIARAJOHNSON.
You can proceed, counsel.
Thank you, Your Honor. Ms. Johnson, thank you for being here. Good morning. Thank you for being here again. I should say, we've had to do this twice now. As the judge advised, Mr. Freeman will need both of us to pick up our voice a little bit. So maybe just pretend like you're trying to talk to the back of the courtroom at your dad back there, okay? Sierra, do you live in Lansing?
Yes,
Where do you live?
230 Hill Street.
What is located at that location of 230 Hill Street?
My home.
Do you do anything for work?
Yes,
What do you do?
parking enforcement, and I work for Domino's,
Which Domino's location do you work at?
South Cedar.
How long have you been in Lansing?
About 14 years now.
Have you always lived at that house at 230 Hill Street, or did you have to move there?
No,
Did you move there because of a person named Terrell Williams? To avoid a person named Terrell Williams, I should say?
Objection leading.
Objection sustained.
You know a person named Terrell Williams?
Yeah.
How long have you known Terrell?
About 4 years,
How do you know Terrell?
we dated.
Do you see Terrell in the courtroom with us here today?
Yeah.
Could you please point him out and identify him by an article of clothing he's wearing?
Right here in the booth.
Your Honor, please let the record reflect the witness has identified the defendant.
Without objection.
So noted.
That location of 230 Hill Street, is that in Lansing?
Yes.
Is that in Ingham County?
Yeah.
State of Michigan?
Yeah.
Before we get to the date of July 27th, I want to talk about something else. At a certain point, did you file for a PPO, a personal protection order against the person named Terrell Williams?
Yes, I did.
Do you know if that PPO was granted?
Yeah.
Do you know if it was served on it?
Yes.
Was that PPO active and valid on the date of July 27th, 2024?
Yeah.
Why did you get a PPO?
This kind of year for my face.
Have you had an incident?
We had previous, domestic before in the past. I guess it was just to, secure myself,
Were you afraid?
so a degree, yeah.
You take any measures aside from getting that PPO to protect yourself?
Just by calling law enforcement when I needed it.
That first incident, the one that caused you to get the PPO, did you want that contact to happen?
No,
Is that why you got the PPO?
yeah,
At some point after that PPO being granted and served, did Terrell show up at your house?
yeah.
What happened on the date of July 27th, 2024? Recall that date?
Yes.
What happened?
I was sitting upstairs in my room, getting ready to shower. And get
I'm
ready.
sorry, Judge, just a little loud, please.
Okay. I was upstairs getting ready, well, about to get ready to take a shower. I heard, I think Terrell's car pulling up outside. I immediately locked my doors and I went back upstairs to continue on doing what I was doing.
Let me stop you there.
Mhm.
Why'd you lock your doors when you saw Terrell's car?
Because I knew he was about to come to my house.
You gotta speak loud.
Because I knew he was about to come to my, come to the house.
What made you think that?
I car pulling up outside.
Where outside? Right on the street, right in your driveway?
People on the street and my driveway is in the back of the house. So you have to come in front of my house, make a right, and then make another right to park in the back.
So you went upstairs to continue showering. What happened after that, after you locked the doors?
I heard a big loud boom. Next thing I know, Terrell is in the house. I hear some glass shattering, but I'm not upstairs. I'm right here, so I stay in my room. Once he makes it upstairs, he just kind of kept telling my company to leave and wouldn't let me out of the bedroom. So that is when he began choking me, holding me down on the bed. He wouldn't let me pass to go down the stairs, like so I could go outside. So I instead had to go outside on the roof, which is where I caught the cold.
Let me back up a little bit and break this down. So you said you heard a loud boom when you were upstairs.
Which was my front door being kicked in.
How do you know that?
Because my door was not kicked in. I had just locked it. It wasn't locked.
Did you see any damage on the door frame itself?
Yes.
Would you recognize a photograph of that if I approached you with it?
Yes.
Your Honor, approaching with people stipulated exhibit number 2.
That is my front door.
That's your front door?
Mhm.
Publishing.
Is that a yes? Is that a yes, ma'am?
Yeah.
You also mentioned you heard what sounded like glass shattering. Do you have any idea what caused that?
Because I was upstairs hiding, not hiding, but just staying upstairs. I don't know if at that point was my windows being broken or was that because I have a glass coffee table in my living room. I don't know if it was that or the windows being broken. I was upstairs, but all I heard was glass being shattered.
At some point, did you see your windows broken?
Yes,
Would you recognize photos of those if I approach you with them?
yes,
Permission to approach with exhibits number 3 and 4, Your Honor. You recognize what's in those exhibits?
yes, my dining room windows,
Those windows look like that before Terrell got to your house?
no,
Do you have any idea how those windows got like that?
Terrell broke it.
Now, before we get up into what happened in the room, I want to talk a little bit more about what was done downstairs. Was there other damage done to your personal property?
My TV, my 65-inch TV in the living room. And again, the coffee table, which is like the glass that was all shattered all over the floor. The holes in the wall.
I'm going to approach you with some more photos here, and I just want you to tell me if you recognize these.
Yeah.
Approaching with people's exhibits stipulated exhibits number 5 through 8, Your Honor. Just flip through those for me. Tell me if you recognize.
Yeah. Do I need to state what they are?
Yes, please.
This is the wall when you walk in to my front living room, like right after you walk in past the front door. This is my living room TV, which he punched and broke. This one is my bedroom TV, which he punched and broke. Right here is where my coffee table used to be, but he broke it and shattered it.
Who did all that property belong to in those photographs?
Me.
Who broke or damaged that property?
Terrell Williams.
The cost that, and now you don't have to give me an exact number, but the estimated damage for all of that property that he destroyed, would it be more than $1,000?
Yes.
Less than 20,000?
Yes.
Posting to your eye. Aside from what I showed in those photographs, is there any other property damage that would be significant for this court to know about that day? I want to back up and go back to what happened in the room now, okay? Who, if anyone, was lawfully present inside your home when Terrell showed up?
My son.
What about you?
Yes, I was.
Did you have a right to be in your own home?
Yes, oh, sorry.
I know it's a silly
Besides
question.
me, I'm sorry.
That's okay. You mentioned a friend.
Mhm.
You had someone else with you?
He was there, but Terrell kept telling him he had to leave. So he just kind of like left.
You know who that person is?
Jermaine.
Jermaine. Did Jermaine, do you know, provide a statement to police?
No, he wasn't there by the time the police got there.
Are you willing or comfortable to identify Jermaine by his full name in court today?
Jermaine Taylor.
Jermaine Taylor. How do you know Jermaine?
I've known him for about 2 years now.
Did it seem to make the defendant upset when he saw Jermaine in your room?
Yes.
Why?
I'm not really sure why, because me and Terrell had broken up way prior before this. So I'm not understanding why he was upset about it. But yeah, it did upset him.
Is it fair to say that you and Jermaine might have been dating?
We are.
We're hanging out, you still are?
Mhm.
Okay.
Sure, yes. Yes, I'm sorry.
So would it be fair to say that your ex-boyfriend Terrell showed up and saw your new boyfriend in the room with you?
Yes.
This made him upset.
Yes.
What happened after that?
Terrell kept telling him he had to leave. My friend was trying to collect his items. I really don't know. I can't remember exactly what they were doing, because I was like trying to get downstairs or to safety. He wouldn't let me pass him, so like every time I kept trying to go down the stairs or into a different room, he wouldn't let me pass. My only way out was going through the window out onto my roof.
Let me stop you there. When you said that he wouldn't let you pass him, just to be clear who you're talking about.
Correct.
You mentioned having to go out your window. Would you recognize a photograph taken of that window?
Yeah.
Approaching the witness with people stipulated exhibit number 9.
My upstairs bedroom window, that's.
Is that the window that you had to sneak out of? What, if any other way, did you try to get out of that room?
I kept trying to go down, like, walk down my stairs.
How did Terrell stop you? Physically?
Physically, at first it was choking me and then he was just like holding me down. You know, he's a lot bigger than me, so my efforts to push past him weren't doing anything.
What were you afraid of? You mentioned that you were trying to go downstairs to get to safety. What, if anything, were you afraid of?
Him assaulting me, he's done in the past, so, yeah.
Were you, how afraid were you of some bodily harm? Were you afraid for a cut, a bruise, your life? Please explain.
I would say I was afraid for my safety.
I'm sorry.
My safety?
Were you worried that he might try to kill you?
It crossed my mind. I wasn't exactly sure what was going to happen. I didn't know I wanted to get out.
To be clear, this was after you had already gotten a PPO granted on him?
Yes.
Did you suffer any sort of emotional distress as a result of this? Have you been emotionally affected by it?
Objection
now,
as to the relevance of that.
Relevance?
Yes, Your Honor. According to criminal jury instruction 17.25 for aggravated stalking, one of the elements that I have to prove is what sort of emotional distress she suffered or what a reasonable person would or would not have feared. So I think it's highly relevant to this case.
Objections overruled. You can answer the question.
Sure. What, if any, emotional distress did you suffer by this? Have you been emotionally affected?
Actually, yes, I started therapy and I already suffered from depression and anxiety, so it just made it like 10 times worse.
When Terrell stopped you, and you mentioned that he started to choke you or strangle you, I think might have been how you put it. Please describe that in detail. Where did he put his hands?
Around my neck and pushed me onto my daughter's bed. Just one time across the hall into my daughter's room, and he held me down on my daughter's bed and choked me.
Did he use both hands? One hand?
Can't really remember, and I don't want to lie.
Fair enough.
I just remember being choked.
I don't want you to lie or guess either. I appreciate that. You say that you remembered being choked. At any point, did you have difficulty breathing?
I did.
Did you lose consciousness?
No.
How difficult was it for you to breathe?
Pretty difficult. It was hard for me to even talk to Officer Clue and the other officers that were there because my voice was like kind of strained from like screaming. I did trying to, you know, get for air or whatever.
How long did he have his hands on your neck when you couldn't breathe?
I would say about 1 to 2 minutes, maybe.
How, if at all, were you able to get away from this?
I just like was trying to wiggle my way away, and when I finally did, that's when I darted from my room and out the window.
So you had to go out the window of your house. What happened after that?
I stood on the roof and I called the police. That's all I took. I didn't go into my house after that. I didn't go back into the house until when the police was outside.
Would it be fair to say you waited on your own roof at your own house until police arrived?
Yes.
Was that because of what the defendant did?
Yes.
What, if anything, did he do after you made your way out the window?
I heard some more glass breaking and then I seen him pulling off.
Now, let's talk about what happened after you spoke with police. Do you have any information or know if the defendant Terrell had a bond based on this incident?
As of that day, July 27th, was he out on bond?
No. As a result of this incident, did he get a bond that you had notification of?
Yes,
Did he also have a tether that you were getting notification?
yes.
What, if anything, happened regarding that tether and him continuing to see you after those orders were put in place?
I got a notification that he was 621 Hosmer Street or 641 Hosmer Street. I'm not exactly sure of the address, but on Hosmer, which is the next street over from my house. A few nights later, he was at my job ordering food.
Do you recall the date of August 8th, 2024?
I do,
Were you working on that date?
yes,
Where were you working?
Domino.
You said that he showed up at your work. How do you know that?
Because I was at the window taking orders and handing out orders. As I went to go help the next customer, which would have been him, it was him. So I immediately went over to the door and I told one of the other employees if we had to help him.
Is your Domino's the only Domino's in downtown Lansing?
No,
Is there any,
it's not downtown, it's South Cedar.
do you happen to know where the defendant was staying at this time?
No.
So would you know if this Domino was out of his way at all? At some point, did you submit a receipt for that order that the defendant placed when he came to pick it up?
I did.
Would you recognize that receipt if I approached you with it? Approaching with stipulated exhibit people's number 11. You recognize that?
Yes,
What's that?
it is the order for his Alfredo and the weed bites. It has his phone number and his name on it. Well, middle name, sorry.
What's that date and time?
August 8th, 2024, 10:16 p.m.
You said it had his name, his middle name.
His middle name.
How do you know his middle name?
Because I dated him for a year.
What is his middle name?
Lee.
What's his phone number on it?
517-410-0137.
Seems like you knew that number pretty fast. How's that?
Called it a million times.
So you recognize that as a number that he had?
Yes.
Approaching your honor to publish.
No problem. I have a question. How long have you worked at the Domino's?
I've been at Domino's since May.
Of this year?
Yes.
You continue.
No further questions for the witness at this time. Thank you, Your Honor.
Cross exam.
Thank you, Your Honor. Mr. Johnson, I don't have too many questions for you. I just want to clear up a few things. If you don't understand any of my questions, just let me know and I'll rephrase, okay?
Yes.
Thank you. I believe you testified that Terrell Williams was responsible for all the damage that you told us about. Is that right?
Yes.
And did you see him break any windows?
No.
Did you see him damage your television?
Yes.
Did you see him damage your coffee table?
No.
Did you see him damage your door?
No.
Did you see him damage the wall?
No.
Assumed it was him. Is that a fair statement?
Yeah.
Assumed that he was responsible for all of that damage. Is that
Yeah.
okay? Thank you. Are you still in touch with the, I'm sorry, was the gentleman's name Jermaine?
Yes,
Have you had a conversation with Jermaine about this
No.
since it happened?
no,
I'm sorry?
no,
Are you able to tell us today whether Jermaine witnessed Mr. Williams damage any of your property?
he witnessed the TV and he witnessed him choking.
Same thing that you did.
Mhm.
Is that a yes?
Yes,
Thank you. Can't say, you have to say yes. Thank you. I'm curious about your relationship with Mr. Williams. And if I understood your direct testimony, you said that the two of you had, well, for lack of a better phrase, had split up.
yes,
Does that sound right?
Yeah.
And about how long ago before this date had you split up?
um, ending of March, beginning of April.
And this was in July, correct?
Yes, yes, I'm sorry.
Thank you.
Keep forgetting.
I don't want you to think I'm picking on you.
No, you.
We might need a transcript, and that's why I'm
I
asking you.
understand.
All right, thank you. And when did you get that personal protection order?
March, April.
Okay.
I can't remember the exact date, but it was March, April.
Had you reported any violations of that PBO between March or April and July?
No.
Had you seen Mr. Terrell Williams between March and July?
Yes,
More than once?
yes.
How long had you worked at Domino's? I'm sorry,
Since May.
since May? Split up in March or April. You started working there in May. And then this episode that you described for us today was in July. Is that true?
Correct.
Okay. Do you have any reason to think that Mr. Williams knew that you were working at that Domino's?
I don't.
Do you have any reason to believe that he knew the days that you were working or the hours that you were supposed to work?
I don't.
Do you have any reason to think that he knew you were there on the day he stopped for something?
No.
Did you have a hearing recently with respect to an alleged violation of this personal protection order?
You said that I have a hearing.
Yeah, about a week or so ago.
That was
I'm
was
sorry.
that the one that occurred last week?
Well, I'm just curious as to whether you were summoned for a hearing regarding this same
Yes,
PPO that we've been talking about.
yes,
Okay. And is it your understanding that that allegation was dismissed?
yes.
Thank you. The damage amount that you told us about, that's a guesstimate on your part, is that fair?
The.
You're estimating.
No, not really. Because I bought all my things, so I know exactly what they added up to. The estimate I gave for my windows is exactly what Hans quoted.
Okay. It's somewhere between 1,000 and 20.
Yes,
Does that sound right?
yes.
Okay.
My windows by yourself were about 4,000 for me.
You got those repaired already?
No. Two of them have been repaired. I'm working on the other two.
I think that's all. Thank you. Thank you, Your Honor.
Correct.
Yes, sir. Ms. Johnson, on cross-examination, you were asked about whether you assumed the defendant broke these things or if you knew.
Mhm.
To be clear, who all was inside the house when he showed up?
The only person that were in the house was me and Jermaine. We were upstairs.
You and Jermaine was upstairs.
Mhm.
Who was the only person downstairs when you heard all that damage?
Terrell Williams.
When you went downstairs after the police arrived, was your property damaged?
Yes.
Was that in excess of $1,000? In total, everything he did?
Was it only $1,000?
Was it more than 1,000?
Yes.
Was it less than 20,000?
Yes.
How confident are you in that number?
Very confident. 100%.
This PPO hearing that you were asked about on cross, do you have any understanding or know why it was dismissed?
They say that they hadn't served him, but I know in March, Terrell had entered my home. My alarm system went off. Police came and let him know right then and there that he had a PPO. They did it over the radio to serve him. He said that he understood, he got his things and he left. So to my understanding, I thought that that was him being served.
Fair enough. And did an officer respond to assist you on this? The incident on July 24th?
Yeah, yes.
Do you recall who that officer was?
On July 24th or
Right, when he
27th?
broke into your house?
27.
Excuse me, yep, 27. You recall
July-
who that officer is?
Uh,
Officer Clue,
Clue.
perhaps?
Yes,
Would he be better to ask about whether or not a PPO was served?
yes.
Thank you, Your Honor. I have no further questions. This witness can be excused.
I just have one follow-up question about the incident on August 8th at the Domino's. You said you were the one taking orders?
Yes. I was handing out orders.
Oh, you were
and-
handing out orders?
Yes, we don't take orders at the window.
Okay, so was it a drive-through?
Yes, he had came through to get his first order, noticed that I was there, and that's when he placed that order that I took a picture of. So he had been there twice.
Oh, so twice the same day?
Yes,
Got
after
it.
he figured out, yes.
Okay, thank you.
If I may follow up on that, Your Honor.
Yes.
To be clear, did Terrell also, or at least did you get notification that he was in the same area as you a week prior to that?
Yes,
Maybe not even a full week prior to that?
yes, on Armstrong Street,
Have you already had to come to court once for this?
yes.
What happened then?
Terrell Williams ran out of the, well, he said that he had to go to the bathroom, but he said left work so that he wasn't seen.
How do you know that? Did you see it?
Yes,
Did you get any notifications from the tether after that?
yes.
What did you get notification of?
That he had tampered with his tether. I guess meaning that he had cut it off. I don't know what tampered means,
Fair.
but when it popped up, it just was letting me know that he had tampered with it.
And that was the same day as this prior court hearing that was set already?
Yes.
What happened in the time between then and now? How have you been feeling? What's happened at your house? Have you had officers stationed at your house?
Yes.
Why?
For me and my kids' safety and well-being.
You have kids that live with you too? Yes. Is that a yes?
Yes,
Fair to say the past month or so where you had no idea where the defendant has been, fair to say that's affected you emotionally?
yes.
Okay, if you need a moment. How has that affected you?
Since he's been in custody, not really, but before you guys have found him, again, I work 2 jobs and I also currently take classes at LCC. So between trying to do all those and care for my kids and not knowing exactly where he was, I was concerned for my safety.
I have no further questions, Your Honor.
Your Honor, the court did raise an issue. I'm used to a Domino's store being, 2 glass entrance doors. You walk in and you take care of your business and you walk back out. Did I understand this one has a drive up, the one that you worked at?
Yes.
Okay, can you help me understand you're seeing Mr. Williams on the date that's on that receipt. Did he come at the drive up? Help me
He came to the
understand.
drive-through. I work in the store. I'm an assistant manager, so I don't go out. I don't do deliveries or anything like that. I work strictly in the store. So I'm either on make line or I'm at the window. I was at the window this particular day. When I see Mr. Williams at my window, I step back and I have one of my other employees help him instead of me helping him. About 10 minutes later, he placed that second order.
He drove, I guess, up to or through the drive-through a
He came to
second
the
time?
drive-through window and got his food.
A second time is the question.
The second time, no. I don't know about the second time because honestly, after the first time, I stepped outside and I got in contact with LPD, which is the night that I talked to Officer Clue. So after that, I really was at the back of the store, talking with LPD.
Did he try to come in or contact you or communicate with you?
No,
The second order, was it different than the first order?
I'm not for sure. I didn't, as soon as I seen Mr. Williams, I left the window and I walked to the back of the store. I had
Okay.
someone else help me. I have no idea.
So we don't know if he ordered a pizza or a sandwich and then, oh, I gotta get a drink and come around and get something else. We don't know.
No,
Okay, thank you, Judge.
When you saw Mr. Williams, did he see you?
yes,
Any further questions?
Your Honor, just permission to approach and retrieve People's Exhibit number 11, so we
Yes.
can read exactly what the order was. Read that order for us here. You were asked if he just forgot a drink. What's that order?
2 pasta Alfredos and 2 Philly cheesesteaks, 4 items total.
You work at Domino's, so I'll defer to your expertise on the matter. Is that enough food for a person?
No, I mean, yes, yeah, 2
For-
people,
More than one person?
yeah.
Thank you, Your Honor. No further questions.
Is going to be excused?
Yes, Your Honor.
Okay, thank you. Ma'am, you may be excused.
Thank you.
You can call your next witness.
We'll call Officer Clue to the stand.
No.
Yeah, I'll make him quit, but yeah, that was the main reason. Okay. Your Honor, I believe we have a stipulation to service of the PPO based on the testimony prior to this incident date.
Sounds good. I'm still calling the same witness, so.
Yes, Your Honor, it will be much more brief. Thanks for going to seat.
No, anyway. Okay, so it's food items.
Yep. Wilson's good. So Detective Wilson, we might not need him after that. People are now calling Detective Sarah Wilson.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes, Your Honor.
State your first and last name and spell both.
Sarah, S-A-R-A-H, Wilson, W-I-L-L-S-O-N.
You can proceed, counsel.
Thank you, Your Honor. Good afternoon now, Detective Wilson. Thank you for being here as long as you have. Are you currently employed?
Yes, I am. With the Lansing Police Department,
How long have you been employed with the Lansing Police Department?
about 15 years.
What is your current rank and assignment?
I'm a detective in the domestic violence unit.
How does one become a detective in the domestic violence unit? Is there more training, more education?
There could be a little bit. I haven't actually been in the unit that long, so I haven't gone to the specialized training. I certainly did have training in the academy and throughout my career for domestic violence issues.
Fair enough. How long have you been a detective? Let me ask that.
About 5 years.
5 years is not that long to you?
Well, I've been in the domestic violence unit for since about January.
Got it. What do you do in your role as a domestic violence specialty detective, or maybe just a detective in general?
Generally, we're assigned cases that parole officers have taken and follow up on them. If there needs to be additional statements from victims or witnesses, or accused potentially. Certainly in domestic violence, a lot of what I do can be like pretrial release violations and that kind of thing. There's a lot of follow-up with that.
Do you have any experience with working with the JSG monitoring company for GPS tethers?
Yes, I've had to contact them before on several cases.
Do you have any experience with aggravated stalking, cases like that?
Yes, I've had several.
What about with suspects tampering with or cutting their tether?
I don't know. I specifically had that one before, but during this incident, I did deal with that. Yes.
Fair enough. Let me cut to the chase. Were you at some point assigned to investigate a suspect known by the name of Terrell Williams?
Yes.
Do you know who Terrell Williams is?
I hadn't personally met him before, but he was the accused in a domestic home invasion incident and subsequent violation of pretrial disorder.
At this point now, do you know who Terrell Williams is and what he looks like?
I've seen his image before, and he appears to be the person sitting. The lawyer over here.
Let the record reflect Detective Wilson has identified the defendant, Your Honor.
Without objection.
Noted.
At some point, were you assigned to do some follow-up regarding tether violations from Mr. Williams?
Yes.
Would you recognize copies of those reports if I approached you with them?
Yes.
Permission or approaching with people's stipulated exhibit number 10, Your Honor, it's multiple tether violations. Please flip through that document. Just tell me you recognize it first.
I do recognize these as the JSG reports that you tend to get.
What does it mean when someone's in the exclusion zone?
Well, generally on pretrial release orders, they will have a 2,000 foot, if the judge sees fit to include that stipulation, there's a 2,000 foot prohibition from being from a particular location, such as the victim's home, work, or school.
Do you know if the defendant, Terrell Williams, had that particular condition on this case?
Yes.
So what are we looking at in those reports then?
Those reports were looking at the GPS on his tether indicating that he has violated that exclusion zone and is within 2,000 feet of areas he's not supposed to be in.
Did you do any follow-up or investigation to determine why he may or may not have been in those areas? It's okay if not.
I did not.
Does it list on that report any, if he gives a reason why he was in that area, will it be listed on that report?
I would expect it would be. I haven't seen those kind of reports myself.
Fair enough. Were you made aware of a prior court date that we had scheduled for a preliminary exam on this case at a certain point?
Yes, I was, or I learned of it, I believe, on August 15th.
Were you assigned to do some follow-up after that preliminary exam that was scheduled?
Yes.
Why?
Because my understanding is Mr. Williams had run from the court building for a hearing and then subsequently cut his tether.
Were you able to confirm whether or not his tether was cut?
JSG monitoring did provide a report stating that they had a tether hamper cut incident. I'm not quite sure how to word that.
Is there a difference between a tamper and a cut?
I don't know how they do that exactly. I think you could tamper it without completely severing the tether, I would think, but I am not expert in that. I believe the report said that it was cut. They reported.
And at any point, did you assist in recovering the suspect, Terrell Williams, or did someone else handle that?
Someone else handled that.
I have no further questions. Thank you, Your Honor.
Cross exam.
Detective Wilson, is that right?
That is right.
You had an opportunity to review those, if you don't mind, I'll just call them GPS reports. You get a chance to look at them?
Yes, I have.
Did you come away with an understanding that a majority, if not all of them, were short in duration? 5 seconds, 10 seconds, 15 seconds, something like that?
I believe they were not exceedingly long.
I'm sorry?
They relatively short in duration, yes, I'm not exactly sure how long.
Okay. And were you able to determine to your own satisfaction as to whether, well, Mr. Williams was on foot or in a vehicle?
I don't know exactly. I know at least one of the incidents on the 4th. The GPS was hitting while traveling some distance. I would expect he was probably in a vehicle, but I don't specifically.
I'm not asking you for, a mathematical equation. I'm not asking you for an expert opinion. I mean, I read it.
Yeah.
And you read it. And I can't put into evidence what my opinion was, so I'm asking for yours. Did it just seem to you, in your opinion, that most of these would have been consistent with someone who was in a vehicle?
If I could review just a second for the ones I have in front of me here. I know certainly some of them, like the one, let's see, on August 4th. Around 3:17 a.m. I know that hit in several points in the exclusion zone. That I would expect he was probably in a vehicle then. There's only one point on the other date on the 4th. 10 p.m. On the 9th, so it may be reasonable he was in a vehicle. 2 points some distance apart in a very short time. Certainly in several of them, yeah. He's probably in a vehicle.
Okay, thank you. Did any of those give you the impression that Mr. Williams penetrated that zone and stayed in the zone for any length of time?
Not for long. I wasn't sure on the first one on the 4th, he kind of comes up from a little side street and then goes
For more than a
down the
minute?
zoo, but
Let me help.
yeah. I would have to look at the times here. I'm honestly not sure if it's more than a minute that he's in the area here. First time on the first incident on the 4th, he starts at 3:17 and the last one's at 3:22. Was there for about 5 minutes going through the area.
Does that tell you if he was in a stationary position, or does it tell you if he was traveling through that zone?
Whether he was stationary at some point, I can't say, but I mean, there's several different points. So I mean, he was.
Okay.
traveling during it.
You said you were somewhat familiar. How is someone, if I'm gonna have a GPS tether on me and I'm supposed to stay away at least 2,000 feet from someone, it also indicates from where they live or work or go to school, I think. Is that your understanding?
Yes, on this particular pretrial release.
So how would I, as a wearer of a GPS, know the schedule of that individual? Know, for example, what building at LCC they're going to be at a certain time, or how do I know?
I am not involved in that process myself. My understanding is someone with JSG, when they actually put the monitor on the person, talks with them about where they're allowed to go and not to go. I don't know exactly how they explain that. But there is a process, and certainly when the judge issues the order, I would imagine that they also explain to stay away from those areas.
Okay. So if the individual I'm supposed to stay away from attends Lansing Community College Monday, Wednesday, Friday, if I drive around LCC on Sunday, I shouldn't be in violation, right?
While it's within 2,000 feet of where they live, work, or go to school, I don't know that
Right.
it means they have to be there necessarily.
Your Honor, at this point, I'd object to speculation. I think we've covered this and we're getting too far down the rabbit hole.
Objection sustained.
Did you say it's your understanding that the GPS tether that was assigned to Mr. Williams had been cut?
Yes, I believe that's what was reported.
Were you told that, or did you see that?
I believe that is in the report. I'm not sure I have that report here, though. That would have been on August 15th.
Okay. Do you know whether it was recovered?
I do not know if it was recovered.
Thank you very much, Detective.
Thank you very much.
Yes, Your Honor. Detective Wilson, do you recall submitting a complaint for a PA 53 violation of conditional pretrial release on this case?
Yes.
Do you recall what the date range of violations you submitted for were?
I think I did two separate reports. One was from August 4th through August 11th with 6 violations. And then the second report was for the August 15th incident on the 4th.
Would August 4th through August 10th for your first report sound right? Would you recognize that if I approach you with it? How about that?
Sure.
Would it refresh your memory on the dates?
Yes.
Just review that and let me know when your memory's been refreshed on what date range you submitted the first violation.
Here's it was August 4th to August.
Regarding that second report, we had an indication of whether or not a tether was cut. Do you recall specifically, or would it help refreshing your memory if I approach you with a copy of that?
It would help refresh my memory.
Wish to approach the witness, Your Honor?
Yes.
Tell me when your memory's been refreshed.
My memory has been.
Do you recall if the tether was cut or you had confirmation of that?
It said within the report that they thought it was cut.
Regarding exclusion zones, do you know if JSG advises people on what the exclusion zones are?
It is my understanding that they do, but like I said, I'm not a part of that process. I don't know exactly.
Does it say on these reports whether or not they advise someone when they breach an exclusion zone?
That they do contact the person when they're within an exclusion zone, that they do that or attempt to do that.
I think Your Honor, no further questions for this witness.
Thank you, Detective. You may be excused.
Thank you, Your Honor.
Any other witnesses?
No, Your Honor. We were going to call Officer Christopher Kluba based on the stipulation to service of the PPO. I think we're good on that.
Argument. Are you calling witnesses?
No proofs, Your Honor. Thank you.
Okay, argument.
Yes, Your Honor. Thank you. Your Honor is well aware we are now here for a reset preliminary exam with Terrell Williams. The reason it being reset has been discussed on the record. Your Honor saw it herself firsthand when the defendant failed to appear, left court in the middle of his scheduled preliminary examination day, and as has been testified to now, cut his tether on the way out. Your Honor, we're here for 4 felony charges that I have to prove were committed by this defendant by a probable cause standard. There is a 5th domestic violence charge that's a misdemeanor and will automatically attach if bound over, as well as a habitual offense notice. The 4 charges are home invasion, 1st degree, assault with intent to do great bodily harm by strangulation or suffocation, aggravated stalking, and malicious destruction of property from $1,000 to $20,000. The preliminary matters that we need to meet regarding location, identity, venue, and date have all been testified to and established on this record. We've established the location of 230 Hill Street in the city of Lansing, county of Ingham, state of Michigan with Miss Sierra Johnson. That's her home where this assault occurred. We've established the date several times of July 27, 2024 is the date when this happened. Importantly, regarding dates, Your Honor, we've also had a lot of testimony about this PPO, when it was served, when it was put in place, when they broke up and all that. What we have testimony-wise from Sierra Johnson is that they ended seeing each other as a result of a prior domestic assault incident around March of 2024. She then filed for the PPO that same month, either March or April is what she says. We have a stipulation to service of that PPO based on her testimony that she was sitting right next to officers when they informed him of it, and the defendant said he understood. Whether a valid PPO was in place or not is not in question based on that testimony, Your Honor. I bring that up because according to criminal jury instruction 17.25 for aggravated stalking, to make it an aggravated count, the 6th element I have to prove is that one act was in violation of a PPO. That PPO has to be validly served and validly active when this happens, and we've established that. Working backwards now, the 1st element I have to prove is that the defendant willfully committed 2 or more incidences of unconsented contact with Sierra Johnson, that the contact would cause a reasonable person to suffer emotional distress, that the contact caused Sierra Johnson to suffer emotional distress, that the contact would cause a reasonable person to feel terrorized, threatened, frightened, intimidated, or harassed, and that the contact did actually cause Sierra Johnson to feel that way. Your Honor, we have the prior instance that a PPO was filed for. That's unwillful contact number 1. Then, after the PPO was ordered and in effect, and Sierra moved houses, he found her new house, broke in, and strangled her there. Unwanted contact number 2. On top of that, we have these GPS violation reports I'll approach Your Honor with now, showing several instances where he was within the exclusion zone. I understand that there is some arguments made about the exclusion zone and whether or not he was in a car, if he was just passing through, and all that. What we do have for sure, Your Honor, is an incident on August 10th where he went right to her work, ordered at the drive-through window, saw her, and then placed a second order to go back around with his name and phone number on it, his middle name and his phone number that you have a receipt for as well. Your Honor, I think we've got 2, if not more, instances of unconsented contact with Sierra Johnson. She testified that not only would a reasonable person have felt emotional distress because of this, she actually did, and she's seeking therapy and treatment for it as well. So whether or not this contact would have caused an individual to suffer emotional distress, and it did, has been proven, as well as whether a reasonable person would have felt terrorized, frightened, threatened, harassed, or intimidated. She had a PPO in effect, and then this man showed up at her new house, broke in, broke all of her things, tried to choke her, and tried to kick someone out that she was staying with. She had to flee out of a bedroom window and sit on the roof until police came at her own house because of what this man did. Whether or not a reasonable person would have felt terrorized, threatened, frightened, intimidated, or harassed has been met, and it did in fact cause Sierra Johnson to feel that way as she's testified. Regarding home invasion, first degree, Your Honor, I'm looking at criminal jury instruction 25.2A. The defendant did break into her house. Sierra Johnson testified she saw his car pull up, suspected he was going to try and enter her home, and locked her front door as soon as she saw the car because of how afraid she was for her safety. Then, when she was upstairs with the only other person in the house, she heard a loud boom from downstairs, and Your Honor has a photograph of the door frame being busted up there in People's Exhibit number 1, I believe it is. Not only that, there's a window that was broken that you have photographs of. Now, it's my suspicion that the defendant broke through that door and entered through that door, and that's how he broke and entered based on the evidence that was presented today, and the windows were done as a malicious destruction of personal property, not a way to get at. But regardless, Your Honor, we have circumstantial evidence to prove either. Not only that, but as charged, the third element I'm required to prove, the defendant did commit malicious destruction of property once inside. We have undisputed testimony about that. You have several photographs. 2 TVs were broken, which might equal more than $1,000 by themselves based on their size. Not only that, the victim, Sierra Johnson, testified to the value that she has actually gotten quotes for her windows, and she is very confident, knows for a fact, the range of the extent of that damage is between $1,000 and $20,000. Fourth, Your Honor, for home invasion, I have to prove that victim Sierra Johnson was lawfully inside when he did it. We have that testimony. Regarding malicious destruction of property, since we're kind of already there, I've established the fourth element that the extent of the damage was between $1,000 and $20,000. Working backwards to the first element, we've established through Sierra Johnson's testimony the property belonged to her. We've established that the defendant destroyed or damaged that property, not only circumstantially, but directly. She stated that she directly saw him punch her TVs and break those. She also stated that she heard all of the noise and commotion while she was hiding on the roof until police came. That resulted in all of the other damage downstairs when the defendant was the only person inside. The defendant did it knowing it was wrong or with intent to damage, and destroy is the third element, Your Honor. Punching someone's TV, breaking all their things after breaking into their house and assaulting them, I think any reasonable person would understand is wrong. And the intent to destroy was clear because he did actually destroy it. Finally, Your Honor, with regards to assault with intent to do great bodily harm by strangulation or less than murder by strangulation or suffocation, I'm looking at criminal jury instruction 17.35. The defendant committed a battery on Sierra Johnson. Second, that he intended the touching. And third, that it was committed by strangulation. Specifically, that means that he either impeded the normal circulation of blood flow by applying pressure on the throat or neck, or that she had difficulty breathing. She testified very clearly to her difficulty breathing. The fact that this was over a minute, the fact that her only way out was to wriggle and writhe and try to force him off of her while he had her pinned down on her daughter's bed with his hands on her throat, trying to strangle her. And the only way she was able to get away was by luck, grace of God, whatever it is, she was able to sneak out the window and get away. And that's the only way this assault happened. And quite frankly, Your Honor, probably the only reason that this assault wasn't more serious. Last thing is, Your Honor, I think I failed to mention the criminal jury instruction for MDOP. It's 32.2 with that for arrest.
Mr. Freeman.
Thank you, Your Honor. The defense objects to the motion to find over count 3, the aggravated stalking. And the reason is the willful course of conduct has to involve repeated or continuous harassment of Ms. Johnson. She testified at great length about July 27th, and that day caused her to feel terrorized and so on, and met, I would stipulate, the requirements. But I don't recall any other testimony where she indicated that would be considered by this court to be a repeated or continuous harassment of her. I think that the citing of Mr. Williams at the Domino's Pizza was clearly explained that she herself said, no, he wouldn't have any reason to know that I was even employed there, or that I worked there that day, or that those were my hours. And so apparently he pulled up the drive-up window, and the receipt that we have in evidence indicates 4 food items. And we don't know why he drove through there a second time. We don't have a receipt for that, unfortunately, but we do know that her testimony was that he didn't get out of the car, he didn't come into the store, he didn't try to contact her, he didn't try to have any, communication with her. So that would suggest that the second pass at the drive-up wasn't aimed at her. It was just aimed at completing his food order, whatever that might be. So I think that was just an innocent passing. And does not constitute a repeated or continuous harassment of Ms. Johnson. Also, if that was to be considered by the court, or I think counsel also indicated the first, back in March or April when the PPO was first gotten, I don't believe that we have any evidence that even if those were to be counted as repeated or continuous, that they she didn't indicate any testimony that would allow the court to believe that she felt terrorized or frightened or intimidated or threatened or harassed. It was all about July 27th. So I'm concerned about the count 3 aggravated stalking. I'm not sure the people have quite met their burden on that count. But as to the other 3, I simply will object as a matter of course without any further comment. Thank you.
Yes, Your Honor.
That was in that same address that occurred at the same house with my name.
You can't talk when we're on the record.
Your Honor. Your Honor, with all due respect to Mr. Freeman, who has been doing this job far longer than I, perhaps there is some case law I missed, but I am looking right at criminal jury instruction 17.25 for the stalking charge. I see nothing that requires a repeated and continuous course of conduct. In fact, the second element specifically says that the defendant committed 2 or more willful, separate, and non-continuous acts of unconsented conduct. It's exactly what I argued. It's exactly what the JSG reports show. Regarding the Domino's incident, we had testimony. To be clear, that receipt you have is for the second order. The first order was her at the window, him seeing her, and then him putting another order in for pickup at the store. I would suggest, Your Honor, with hopes to see her again and frighten and terrorize her some more. Not to mention, you've heard a little bit about their history, Your Honor, and I can only speak to what's on the record, but there are prior domestic assaults here that he still showed up to her house after having a PPO served on him. We've met the elements of aggravated stalking, Your Honor. There was no objection to the other elements, so I'll let those rest.
Thank you. Today was the date set for your preliminary examination. The second date set, because the first one we had an incident that the court will address in just a moment. The purpose of the exam is for the prosecution to meet their burden of probable cause. That means they need to show the court that they have sufficient probable cause that these crimes were committed and sufficient probable cause that you, Mr. Williams, was the person who committed the crimes. They don't need to prove each element beyond a reasonable doubt. This is not a trial. They just need more than mere suspicion. Do you understand that?
Yes, ma'am.
Okay, and the evidence can be based on circumstantial evidence or physical evidence or a combination of both, but the court is the sole determiner of credibility of any witnesses, and the court will weigh the likelihood of success at trial. We had, again, a 5-count complaint. 4 of those counts being felonies. First, we had testimony from a Sierra Johnson. She testified that on or about the address of July 27, 2024, that she lived at the address of 230 Hill Street, City of Lansing, Ingham County, State of Michigan. That was where the testimony began. When questioned about how long she lived in Lansing and was she always living at this address, she was clear that she lived in Lansing for about 14 years. However, she did not always live at the 230 Hill Street address, City of Lansing, Ingham County, State of Michigan, which makes venue in this court appropriate, but that she had moved there for her safety, is what she testified. She also testified that she had back in on or about or in between the timeframes of March and April of 2024, that she had to seek a personal protective order, that she had been in a dating relationship with the person she identified in court as Terrell Lee Williams for about 4 years. When asked, excuse me, why she needed to seek a personal protective order, she testified because she was scared for her safety, that they had had domestic issues in the past. And she had some fear about her safety and security. She sought and was granted a personal protective order that she says the defendant was served. She testified that on or about, again, July 27th, she was sitting in her home. She was upstairs. She says she saw the defendant's vehicle pull up. She went downstairs, locked her doors. When asked why she locked her doors, she said because she saw the defendant pulled up and she knew that or expected that he would try to enter her home. She was upstairs with a friend that she identified by the name of Jermaine Taylor, and she heard a loud boom that the defendant came into her home without permission, that they engaged. He actually told someone or her guest that he needed to leave, that he shattered her windows and shattered her 65-inch TV, a coffee table, damaged and placed some holes in the wall. And she said choked, we know and understand that to be a strangulation by placing his arms around her neck. She couldn't recall if it was one or two hands that went around her neck, but that he held her down, she said, pinning her down on the daughter's bed. She described difficulty breathing, but that she did not lose consciousness, but that she suffered some straining during that altercation because she recanted having issues talking when she was speaking to the officers. She described that the attack or interaction continued until she was able to escape onto her roof and call 911, where she stayed until the time the police arrived. She testified that she tried to leave the room and go downstairs prior to that, but that she was prevented by the defendant from retreating. Count one, home invasion, first degree breaking and entering, again requires a probable cause standard that the defendant broke into a dwelling. Doesn't matter whether anything was actually broken. However, some force must have been used. Opening a door, raising a window, and taking off a screen are all examples of enough force to count as a breaking. Entering a dwelling through a already open door or window without using any force does not count as a breaking. Second, the people will need to establish that the defendant entered the dwelling. It does not matter whether the defendant got his entire body inside. If the defendant put any part of his body into the dwelling after the breaking, that is enough to count as an entry. Third, that when the defendant broke into the dwelling, he intended to commit, in this case, the offense of assault with intent to do great bodily harm less than murder. And when the defendant entered into, fourth, when he entered into, was present or leaving the dwelling, that another person was lawfully present in the dwelling. We again had testimony that Miss Sierra Johnson was lawfully present at this address, that her door was not broken or kicked in prior to see the defendant pull up to her home. She testified that after there was a loud boom, the defendant somehow ended up on the second floor of her upstairs at her place and began to assault her. She described this thing a strangulation. The court has reviewed exhibit from the people 2, which show the front door having been kicked open. There's also exhibits 4 and 3, which show windows that have been shattered. The court is satisfied based on that information that there's sufficient probable cause as to count 1 that will be bound over to the circuit court. Count 2, assault with intent to do great bodily harm by strangulation, would require the people to establish at this stage probable cause the defendant committed a battery upon Ms. Johnson, and a battery being a forceful, violent, or offensive touching of another person or something closely connected to the other person. Second, that the touching must have been intended by the defendant, that means not accidental, and it must have been against Ms. Johnson's will. It does not matter whether the touching caused an injury. Third, that the battery was committed by strangulation or suffocation. Strangulation or suffocation means intentionally impeding normal circulation of blood or breathing by applying pressure on the throat or neck, or by blocking the nose or mouth. Ms. Johnson testified that after she heard the boom, she saw or encountered Mr. Williams upstairs, and that he placed his hand, 1 or 2 hands, she wasn't sure, around her neck, holding her down on her daughter's bed, and that interaction impeding her ability to breathe. The court is satisfied that there's sufficient probable cause as to count 2 that will be bound over to the circuit court. Count 3 is the stalking aggravated. The defense is arguing that there's not sufficient evidence to support aggravated stalking. The prosecution would have to establish today probable cause that the defendant committed 2 or more willful, separate, and non-continuous acts of unconsented contact with Ms. Johnson. Unconsented contact means that the defendant initiated or continued contact with Ms. Johnson without her consent, and includes following or appearing within sight of Ms. Johnson, approaching Ms. Johnson in public or private place, appearing at Ms. Johnson's workplace or home, or entering or remaining on the property owned, leased, or occupied by Ms. Johnson, contacting Ms. Johnson by telephone, sending an electronic communication or mail to Ms. Johnson, or placing an object on or delivering an object to property owned, leased, or occupied by Ms. Johnson. Second, that the conduct would have caused a reasonable individual to suffer emotional distress. Third, that the contact caused Ms. Johnson to suffer emotional distress. Fourth, that the conduct will cause a reasonable individual to feel terrorized, frightened, intimidated, threatened, harassed, or molested. And fifth, that the contact caused, in this case, Ms. Sierra Johnson, to feel terrorized, frightened, threatened, harassed, or molested. And for the aggravated stalking, the people would need to establish that this unconsented contact was committed in violation of a court order or restraining order. We had testimony again about a personal protective order that was sought and granted by Judge Lisa McCormick. That's evidence here in People's Exhibit 1. It was signed February 15th, 2024. When asked why she sought the personal protective order, she indicated, she being Ms. Johnson, that it was for her safety because she felt at risk for her personal safety because of prior actions by the defendant causing domestic violence. The second incident, which would count as two or more, would be the allegations that brought us to court today. The allegations that he kicked her door in and strangled her and assaulted her and caused damage, substantial amount of damage, if I were to gather looking at these pictures, to the home that she lives in that she now has to pay for. And then I have a list of alleged contact in violation of the bond conditions. And I think that there was some questions posed to the detective about the duration and whether or not the defendant could have just been driving through. When I look at the duration of, and there's a substantial amount. There's one for the 4th of August for 6 minutes. The court can't reasonably believe that that was someone just driving through when it's been 6 minutes that you are in an exclusion zone and that you are notified by the tether that you're within that exclusion zone. That's on August 4th, 3:17 a.m. to 3:23 a.m. Interestingly enough, there's another one, August 4th as well. Earlier, it says later that day, 1:10 p.m. to 1:11 p.m. Now, this is after having been notified the same day of being within the exclusion zone. Then we go to August 9th, 2 minutes within that exclusion zone. August 10th, 4 minutes within the exclusion zone. August 11th, 1 minute approximately within the exclusion zone. It's not reasonable based on these timeframes for the court to believe that these are just passing through only a couple of seconds when at least 2 or more of these were for several minutes. And one of them or 2 of them happening on the same day of each other. The court is satisfied that there's sufficient evidence to support aggravated stalking based on that testimony and the evidence submitted that will be bound over to the circuit court. Lastly, there is malicious destruction of personal property, 1,000 or more, but less than 20,000. Again, we had testimony from the alleged victim in this matter that first her door was kicked in. The people would need to demonstrate, at least to a probable cause standard, that the property belonged to someone else. Ms. Johnson testified that she owned and purchased this property she alleged to have been damaged. Second, that the defendant destroyed or damaged the property. She stated her door was kicked in after seeing the defendant pull up to her house and even locking the door, knowing that the door at that time had not been kicked in. And then the only other person in the house being the person upstairs with her, there's a reasonable cause to believe that the person who kicked the door in would have been the defendant who later ended up upstairs in the house. She also testified to windows being shattered in a quote for approximately $4,000 for windows. I can see pictures of windows again in people's exhibits 3 and 4. There has not been any quote submitted, but I know how much windows cost, and it's reasonable to think that it costs $4,000 to get these windows replaced. Then there was allegations or testimony about damage to televisions. The court has a picture in People's Exhibit 7 and People's Exhibit 6 of 2 televisions, large, at least probably about 50-inch televisions that have been damaged. There is People's Exhibit 8, which show some debris on what looks like maybe a living room floor and some electronics that look like they may have been shattered. Then there's People's Exhibit 5 that demonstrates a hole in the wall. The court is satisfied based on the testimony that there was damage caused and that there's probable cause to believe that the damage was caused by Mr. Williams and that that damage is more than 1,000 but less than 20,000. Count 4 will be bound over to the circuit court. Bind over date is October 9th. And count 5 will accompany as it'll be bound over as a habitual fourth offense notice. As to the bond violations, we had testimony again about contact that was made in violation of a no contact order. We had testimony and evidence presented about GPS violation reports. I want to highlight the concern or question about the interaction at the Domino's Pizza. Initially, when I heard the testimony that she works at the Domino's, there is no inside, it's just more or less a drive-through pickup, and that she was passing out orders when she noticed or saw the defendant. At that point, it's reasonable to believe that it probably was a circumstance that he may or may not have been aware that that's where she works. However, when coupled with the information that she saw him and she was assured that he saw her, and then after she backed up to have someone else assist him with this order, that another order was then placed within that same time frame. That order not being for a drink. This happening at 11:12 p.m. on a date that I'm sure he had a GPS tether notification that he was in violation of the no contact order. And she testified that he had saw her. He was told not to be where she lives, works, or goes to school. And if he did not know that she worked there, but arrived only to find out that she worked there, then he was not to be there. The court is satisfied based on that there were violations, and based on the testimony supporting these GPS violations that the court have already gone through, that there were violations of the no contact order, multiple violations of the no contact order. And if I were to surmise based on the amount of violations and timeframes of some of them, it's likely that he followed her and found out where she works. That's what the evidence more likely tends to align with, versus he just so happened to be at this Domino's to pick up an order that day. I would believe that if I didn't have a whole laundry list of GPS violations prior to that. In addition to that, we have another bond violation because we were here prepared to proceed on an examination back on August 15th. I called the case. I had already saw and identified the defendant sitting in the back of the courtroom. Case was called. I was notified that the defendant got wind that he had bond violations and that he ran or absconded from the court. I issued a bench warrant and remand. The prosecution did their due diligence in notifying the officers that were present and ready to proceed on a case. And we were notified that they would make efforts to bring him back in custody. However, the court was notified that the tether had been cut and I believe located on Hillsdale, not too far from the court area. Nonetheless, we had testimony from the detective today that supports that transaction or that series of events. The court's going to sustain the second violation as well. Did you want to address the court before I sentence him on both violations?
believe the court has all the information before it in order to make a ruling. Thank you.
Okay, for the first set of violations, I guess I'll do your courtesy as charging him as a set because it's multiple violations. I really could find you responsible for violating on each of them, but we'll take it for August, that you were arraigned on these set of violations, I think on August 15th. And I had revoked bond. I think I intended to revoke the bond. I didn't get a chance because she had left. Nonetheless, your sentence is 93 days Ingham County Jail for the GPS tether violations. As to the violations that occurred on August 15th after absconding and cutting off a tether, the court will impose a 93-day sentence Ingham County Jail. You'll serve those consecutive. And I believe he's been in custody since the 12th on the violations. Again, as to the underlying matter, the matter will be bound over for a circuit court bind over date of October 9th. That's the date the circuit court gets the file from the district court. You do not need to appear in circuit court on that date. Do you have any questions about that?
Yes, ma'am.
What's your question?
The question, like, far as the stated, like, far as like certain, kind of a little confused because, like, I guess went to court on the 20th of last week, and they told me that as far as the PPO, that issue.
I don't deal with PPOs here. You got to talk to circuit court about the PPO. I didn't issue a PPO. What's your question about this case?
Well, far as the, well, one thing far as the like incident at Domino's.
It's a question?
Yeah, it is a question.
Okay.
The question is, like, it's say, like, when I was on tether, I never had a stipulation that I couldn't go to Domino's Pizza.
So you can't be where she lives, works, or goes to school?
I never knew that.
Oh, okay. Well, the testimony was that, and I can believe that there's a possibility out there where you didn't know where she worked. However, her testimony was that you appeared in, she saw you, you saw her, then you ordered something else and reappeared. The court, this is not an engagement about going back and forth. I asked you if you had a question, not really about the evidence, because the evidence has been submitted and there was no evidence to counter that. What you're telling me now is not evidence for me to consider, but anything that you say can be used against you. Do you understand that?
Yes.
Okay. Do you have any questions about what I just told you about what you're serving for the violations, as well as your bind over of the case? That's a no?
No.
Okay. Any additional matters for the record?
Nothing from the people.
Nothing further, Your Honor. Thank you.
Thank you. You're all set.
Still have exhibit.
Oh, I did. Thank you.
Thank you. More time ago. One, all those 93 days don't count to his credit.